Boone, you can proceed, ma'am.
First and foremost, I do not know what it is that you are referring to.
When you say you do not know what I'm referring to, what do you mean?
Motions were filed by the WFTV and the Orlando Sentinel.
Yes, ma'am. So there was a motion to intervene for the limited purposes of opposing closure that was filed on August 12th by WFTV. It was sent to you by U.S. mail at the correct inmate legal mail address on August the 12th. And the Orlando Sentinel's motion to intervene and notice of joinder was filed on August 13th. And it reflects, it said the certificate of service was August 13th, and it was sent to you at the same legal mail correspondence address at the Orange County Jail. Have you received either of those motions?
I have not.
Okay, I have copies.
I have extra copies.
Oh, perfect. All right.
And I do apologize on the Sentinel one, but the e-portal was down for a little while, so while we attempted to file it yesterday, it actually got filed.
That's why I was saying it. The certificate of service reflects the 13th, but the filing information is of this morning. All right, Ms. Fugate has, I am pronouncing your name correctly, am I not?
Yes, you did.
Thank you. Ms. Fugate has provided copies of those motions. So Ms. Boone, if you'd like to take a look at those, feel free to take your time to review them. And then after you've reviewed them, I may have the opportunity to answer any questions you have about them if I can, and then we can proceed.
Cases I know we're going to report on part one. I have extra copies of those.
If you want to provide those to Ms. Boone as well, you can do so. Thank you. State, do you need a copy of them?
Thank you.
All right, thank you, sir.
Is she gonna yell at the papers? I think she will.
Yes, ma'am.
One of my topics of discussion, as you know, are the requests in regards to the laptop and internet being one of the most important. Would I have had access to that, I would have already had this and not had to sit here unprepared. I believe that is a major violation to my due process of me not having these in advance to prepare properly and to utilize the court's time and everyone else's here by me having to do this now. So I wanted to put that out to you that I am unprepared for this. I did not know that I had a statement to prepare as everyone else did also prior to being here.
Ma'am, you were provided the case law as you had requested at our last hearing. It was mailed to you. You asked.
And yes, she thinks she can get out of it by saying, well, I didn't get this and I didn't get that, and it's not fair, Your Honor. But it was fair you got 4 lawyers. And it wasn't fair that you stood up and left the room because they didn't buy what you were selling. That's a big problem. She was provided all the assistance she wanted, but because she's just a know-it-all who can't stand that people say, hey, we can't use that argument because that's not legal. But it's not intentional. That's not a legal term. Yes, it is. I saw a Matlock episode once. I know it's not intentional. That's good enough.
My concerns, it is regarding my case and the whatever is left evidence that is not already on the internet or posted anywhere on social media. And I'm wondering what the reasons for the court other than sensationalism and exploitation. The purpose would be for them to watch me look at the remaining bit of my evidence that has not been globalized.
Honey boo boo, it's not for the court to sensationalize you. You became an internet sensation the minute you straddled that bush and drank off that tap. The court doesn't ask me to stream this. The court probably really don't like that I have 130 people watching this right now. It's not for the court to decide. You have the Sunshine Law in Florida, which means the public got a right to know. I bet you every case with a little bit of excitement that was happening in Florida before this, you were watching on your telly because you seem like a nosy B word. So stop wasting the court's time. You have said this 1,000 times and it doesn't change. It has nothing to do with the court trying to ruin your case by showing they're just following the rules.
Again, my main concern is it is for exploitation purposes, which has already been greatly applied
No, I got famous off Karen Reed.
to my case in many, many ways globally again. And I see on on the motion to intervene for WFTVs, my question is, why is this an important criminal proceeding? I don't
Because you
know
stuffed
why
your
do they
boyfriend
need
in a
to have it
suitcase.
monitored. I don't understand the reasons why just for this one. I'm not asking for all of my other hearings to be closed. Simply, this is my one and only. It is my right to
No,
then spread all on the internet. I'm trying to salvage whatever it is that I can possibly to have a card to play at least one in the end during my trial. I do not feel that it is right lawfully to have them included in this hearing, this one hearing, and I am asking for their admittance to be closed.
Okay.
This is an active, ongoing investigation and case.
Anything else, Pam?
No, Your Honor.
State, do you have any position on Ms. Boone's closure motion?
No, Your Honor.
All right. Any closing remarks from you, Ms. Boone?
Yes, Your Honor. First, I'm only asking for this one hearing, which is a very important hearing. I believe that the press is simply in it for ratings and
of course they are. They are the press. If you want to swing this, don't whine about the press because the press is just grifting just like me. We need content. You're good content because you're an idiot. You say, I'm afraid by disclosing the evidence this early, you will taint the jury pool and it will be impossible for me to get a fair trial. He will say, yeah, but we'll do it anyway. But that's the argument. It's not, don't show I'm an idiot online.
publicity. My evidence is active, and I'm trying to salvage the little bit of anything that I have pertaining to my evidence that is not available online, which would be in that hearing. And I also heard she was speaking in regards to once discovery has been received, it is therefore public record. I just received my discovery for the first time, and I'm still reviewing most, if not all of it. And I have not had the time to go through all of it, but I literally, on the record, just received my discovery to even have an opportunity to prepare to review any of that. And in regards to the hostile publicity, I have letters, I have messages, I have tablet information. I have an entire folder dedicated to publicity in more than one way as being hostile, good, bad, ugly. It's publicity.
It doesn't matter, you Looney Tune. I can pull up the comments I get on my videos. I have good, bad, and hostile too. You are now a public figure because you became a public figure when you stuffed Jorge into a suitcase and made him 2020's hide and seek champion. It doesn't matter to imagine the kind of letters someone get if they, let's say that dad who just pled guilty for doing very horrible stuff to his three kids. Do you think he gets fan mail? And earlier hearing you said there, oh, my fans love me. They're making a GoFundMe so I can reach bond. Come on now.
Will incredibly enhance my inopportunity to have a fair trial because of the already millions of viewers that I have in my case, literally in my case. This would just contribute to it even greater. I'm not asking.
Mr. J, yes, ma'am.
Forgive me. When you stated to the court that my motion was oral, was this during the last hearing that we had?
You requested this both, ma'am, on August 5 and on August 9.
What was it specifically that I requested?
You had requested privacy with regard to the September 3rd hearing. And I advised you that I needed to look at the law on it. And you asked again on September 9th when we were going to address it. I said that we would address it on the 14th. You asked for copies of the law, and those were mailed to you on the 9th.
Which I have yet to receive. And I was not aware of, I was not instructed by anyone in the court, including yourself, that that was an oral motion. If I needed to actually do a proper motion, I would have correctly done so.
That's why we had the hearing, ma'am, because you asked for it orally. So you orally moved or attendiously moved to have that motion heard. And we set it up for today, since we already had the hearing time carved out to address you receiving the hard copies, which seemingly has already been remedied. And last week when we had our hearing on the 9th, I said, I don't want to lose that hearing time because we already had it carved out. So we would proceed with the hearing on the privacy issue at that point in time. You then asked for the case law. I said, absolutely, I will get it to you. Mr. J had advised that he was familiar with the case law. But regardless, it was provided to all parties and mailed to you on the 9th.
Which I have yet to receive. And I was not instructed by anyone in the court that that was an oral motion for me requesting privacy. I thought it was just a comment that I could have on record.
Sarah, I can tell you, you requested and was granted this hearing last week, last Monday, because I put in my calendar Wednesday, the 14th at 1:30, Sarah Boone. I'm an idiot. I don't speak English. I don't spend all my time in prison. I know you had a hearing that day because the judge said we would have a hearing on that day. And you said, okay, you have to be functional late in French to believe what you're saying. Oh.
Ma'am.
No, well, she believes that she had to have made a written motion, but she did state that she wanted a hearing about it, and he said, then we'll have a hearing. She was told there was a hearing today. He granted her wish, and now she's making that a problem. The next thing she'll say is, my hands are really cold. Why am I not shackled? Because you won your hearing the last time not to be shackled. I wasn't told that. You were told that orally. I haven't received that letter. In the same hearing, she was told they were going to have a hearing today about the openness to the press. I have been following another trial at the same time, and I remember better than the woman fighting for my life who was at that hearing. Stupidity isn't an excuse. At this point, it must be because she don't want to listen.
And I'm sitting here waiting empty-handed for everything that was mailed to me day before yesterday and or could have been readily available on the internet, which I do not have access to. So I'm guessing that your verbalization of the order that you read to me, which I have not received, is supposed to suffice.
Ma'am, you were told about the hearing in open court on Friday.
Jesus. Where's Jamie so I can yell at her? This is why I'm single. Imagine waking up one day and your lovely, sweet, beautiful wife had turned into this. For the ladies, I could imagine the same if your husband turned into something like this. She is so obnoxiously stupid.
August 9th.
If I knew to be prepared, I know that everyone knows that I would be prepared, which I am.
No, No one knows you would be prepared because you have never been prepared. You were told, Jesus Christ.
Prepared because of.
That's certainly your opinion that you're entitled to.
Sealed by the CSI right there in front of all of us, and the CSI will reseal it with tape, re-put his or her initials over it with the new date. So
I bet you she will ask if she can touch her phone.
everybody will be on the same page about why it was open, when it was open, so on and so forth.
Thank you for that. If I may, is it closed or is it open to?
No. People that are not involved with the case will not be there.
And if I may, if you know, will my phone physically be there?
I told you. And you can't touch your phone, stupido.
If it is stored in physical evidence, then it can be brought over.
Okay. I'm not understanding why this is being asked.
Because
Because he will make sure that you are clothed like a civilian, but he will also, to protect you and not prejudice the jury against you, give you the opportunity to wear pants to hide your shock collar. Why, oh, why did you hit each and every branch on the stupid tree on the way down? Again, I've only watched your hearings. I know more about what was said in court than you did, and you sat right next to the guy telling you. You said you understood. Whatever.
I want to bring it to your attention that if you have a desire
To put on defense by studying up on the case law and then figuring out how to present it. Who is she going to call and what expert is she meant to get? She want a DV expert that's from her third lawyer, I believe, talked about the money available wasn't enough to get her a DV attorney. What money? The JCA, whatever it's called in Florida, was at the latest hearing. She has already been given 5,500 for a PI. She needs to just cut her losses and plead guilty, but she didn't do it intentionally. Not intentionally. I don't know what she's thinking, but this is the problem. Her mind have been the exact same with the 8 previous lawyers who've been in contact with her. Her problem is she doesn't understand the law doesn't work by Sarah's standard. It works by the letter of the law. And she will cry and moan until she gets locked up forever.
and ma'am, do you have any questions with regard to the USB drive request in your letter and the position of corrections regarding it being a matter of security and how the USB drives are secured, controlled, inventoried, and confirmed to be in good working order?
I understand the process. My only concern is if I'm able to have my hard copy of 2 full boxes of my discovery, I'm not sure why, other than the fact that the assumption could be made that it could be made into something other than a USB drive. And I'm trying to avoid any further leaks of information that could possibly.
Honey Boo Boo, you are in a prison, surrounded by people who might be methods, might be psychos, who might want to take a shift to your spleen because you are the most annoying person I have ever met. They won't give you your USB drives in the dormitory because it can be fashioned into a weapon and it can't leak further leaks of information because all the information is publicly available if it's entered in as evidence because of the law in Florida. At this point, they should just let Berta living on the cot next to her who is so annoyed of listening to her. Could you fit into this pillowcase, you think? Let's try and put you into this blanket and see how long you can survive, and I'll hide. Just let Berta get a free reign of the kitchen and no metal detector up there, because if you're so stupid, you deserve it. Some people are just too dumb to be participating in what's called breathing. And I'm not meaning breathing with two E's, but the one with an A. You are a waste of oxygen.
Be suppressed or utilized in my case.
Jesus Christ. What's the densest material on the planet? No, it's Sarah Boone.
Is there any, if I may please, what is over and above? What other pro se
Jesus, Mother Christ, over and above is more than anyone else in the same situation have been afforded before. You want to have Ritz-Carlton room service in a prison because you are so obnoxious. 4 lawyers had to recuse themselves because you don't understand that the word no also means no when it's said to you. God Almighty. They don't pay me enough to stream this.
inmates, what is it that they've asked for? I don't see how they could successfully even represent themselves without internet and a regular working phone. And
Do you know there's such a thing as a library? You can successfully represent yourself with a law book. You can get a digital copy on your effing tablet. You don't have to sit and say, Google how to get away with murder. You're such an obnoxious idiot. Jesus Christ.
I'm pretty sure that they were not.
Sarah Jessica Boone. I know you're an idiot. I know you couldn't help your boyfriend look for a job when you were on the outside because you didn't goggle that good. Do you know Abraham Lincoln? He was a successful lawyer before he became a vampire hunter. He didn't have the net of Enders. He had a stovepipe, an axe with a shotgun in it, and a whole lot of I can do this. Because that's how you successfully did trials back then. Do you know, even though Al Gore, blessed be his name, invented the internet, he didn't do it so it was publicly ready available until mid 90s, early 2000s, where you started to kind of could look up stuff on it. The world didn't start with the internet. It started with the Lord calling the electrician and said, "Hey, can you make sure we can have light?" And the electrician said, "I'll do it tomorrow." That's how history began. Just because you're an idiot who has to Google how to be pro se, you put yourself in this mess. Ask for a law dictionary and then get to work. How do you think tons of people have successfully and unsuccessfully done their pro se work? With a pen and paper, you blabbering idiot. Jesus Christus. Whatever fun, hope your brain feels better soon. I'm so angry, I'm considering my lord. Jesus Christ. And the worst thing is, she thinks it's a totally cromulent argument that I know internet, I know case, and she will mention this in front of the jury in her opening statement. I haven't been afforded the rights I should have been because I know internet. I in a cell, no hard copy. She's like Veruca Salt. I don't know what.
Counselor,
that's.
if you,
I'm not sure. I'm not sure.
with regard to,
No, they should just say she has been given exactly the same any other pro se inmate have been gotten. They don't, as long as she's given what she asked for within a reason, and the judge doesn't say, well, she should have a phone for herself, she should have a spare office. Then they should just say she is getting exactly the same as Daryl Brooks, as anyone else. She's just a whiny C word.
your,
Thing in writing as a hard copy.
We'll have to check on that. Are you making a public records request?
I'm sorry.
Are you making a public records request?
I'm unclear of your question. I was just asking if Orange.
Are you making a public records request? I'm unclear of your question. I live 7,000 miles away from you, Sarah. I'm a baker. I'm dyslexic. I got by in school because I have a really good brain that retains a shit ton of stupid information, but I couldn't spell. So I left school with an okay average, but nothing more. Then I became a baker. Then I went to the military. Then I went back being a baker, and then I started doing some high school next to it just to see if I could do it. Then I got deployed for a couple of years. Then I came back, became a baker, no, a soldier again, became baker again, joined the reserves. And I know more about American law than you do. All of that I have learned by just watching cases and being a reasonable human being who can understand parts of the English language. You were a straight A student. You lived your entire life in Los Estados Unidos. You have been constantly in contact with the criminal justice system, but you don't understand. Are you making a public request? That's the limit of your understanding. Danielle, this is why I will never come to Florida and visit you. I fear Floridians are like this. Oh, I picked the wrong day. Stop sniffing glue.